The Honorable Chief Justice and Associate Justices of the Supreme Court of California. Hear ye, hear ye, hear ye. The Honorable Supreme Court sitting in back is now in session. Please be seated.
Welcome to oral argument. We're pleased to see so many of you here. The clerk may call the calendar.
Good afternoon. Supreme Court of California oral argument calendar sitting in Los Angeles on Wednesday afternoon, June 1st, 2016 at 2 p.m. Case number S-120659. The People, Plaintiff and Respondent versus Cragen Lewis Armstrong, defendant and appellant. For appellant, Patricia Scott. For respondent, Eric J. Combs. Case number S-222620, the People, Plaintiff and Respondent versus Brandon Lee Reinhardt. For respondent, Mark M. Melnick. For appellant, James Bucall. Case number S-075136, the People, Plaintiff and Respondent versus Daniel Sanchez Covarrubias, a defendant and appellant. For appellant, Thomas Lundy. Ready, Your Honor. For respondent, Richard Dillard.
Ready, Your Honor.
Thank you, counsel.
Thank you, Frank. Calling the matter of People versus Armstrong, you may proceed.
Good afternoon, Your Honors. Pardon me. And may it please the court. Although I am pleased to answer any questions posed by the court today, I would like to primarily focus my argument on issue number 2, which concerned the improper discharge of juror number 5 during the deliberations in the case. In that regard, I'd like to focus on 2 main points today. First, why the 4 reasons given by the trial court for dismissing the juror were insufficient and inadequate to support the discharge. And second, why juror number 5 was actually a thoughtful, capable, diligent juror who was doing her duty and who should not have been discharged. As to the first point, the trial judge gave...
Before you start, would you remind us of the standard of review for the inappropriate discharge of a duty of a juror?
The court reviews, let me restate. The court looks at, gives deference to any decision by the trial court in terms of credibility findings. But the question of whether a discharged juror was properly discharged is a question of both law and fact, and the historical facts behind the trial court's reasoning must be examined for substantial evidence.
And a demonstrable reality that the facts the court relied upon are in the record and the court actually relied upon them, correct?
A demonstrable reality of that, yes, Your Honor.
Thank you.
Thank you. As to the first point, the trial judge, as I started to say, gave 4 reasons for discharging juror number 5. In order of the way he stated them, the court stated them on the record, were, number 1, that she used her cell phone and opened a book during jury deliberations. She had 2, she had reached a fixed conclusion and was no longer deliberating. She had concealed a quote-unquote implied bias in favor of gangs that she could not overcome. And 4th was a scheduling matter. The judge noted that juror number 5 was beginning classes at Long Beach State the following Monday. There was another juror whose vacation schedule was being accommodated, and so there was a limited, abbreviated deliberation period during that current week of just 3 days. The court also mentioned that its own vacation was likely to be interrupted with the proceedings. As to those 4 reasons, I'd like to discuss why each one of them was inadequate to support the dismissal of juror number 5. First of all, with regard to the cell phone and the book, the court did give a lot of attention to this, which is why I bring it up first, because the court did. The conduct by the juror number 5, was de minimis conduct. It was not willful, it was not flagrant, it was not excessive, and the court's guidance about the use of cell phones and books took place way back, at least a month earlier, before the trial had begun, when the jurors had just been assembled as a jury. At that time, the cell phone admonition was not part of the jury instructions. It was 2004. We didn't have smartphones back then. The way the court addressed it was an advisal that you can bring your cell phones, you can bring your books, you can bring them to the jury room. He did advise that the cell phone should be turned off, but again, this was a month before the trial began. And there was no further admonition, no reminder of this point at any point after the trial began, and certainly not.
At what point did the cell phone use take place?
Well, we have to look to the other jurors to ascertain that. Juror number 4 was the foreperson, and she was the first person interviewed by the court. And she mentioned the cell phone use, but did acknowledged at the end of her testimony that she actually hadn't really observed the cell phone use herself, that it had been brought to her attention by other jurors. There was a reference by her that it had occurred during closing arguments and during a readback of the testimony, which was, first of all, not part of the jury deliberations, and second of all, was a little bit strange because it was a time when there were other officers of the court present.
So briefly, counsel, what kind of cell phone use would have made it appropriate for the trial court to remove juror number 5?
What kind?
Yes, how extensive would it have had to be in order to meet what you would take to be the right threshold?
Well, in this case, the jurors, juror number 6 said it was 1 or 2 times, and that was it. Surely that would not be sufficient for dismissal.
So 3 or 4 times, 5 or 6 times? I'm just wondering where you think we should draw the line.
Well, I think it would depend on what the cell phone use was characterized by. Juror number 5 did acknowledge that she had her phone out and she was looking at the time. I don't think the cell phone probably should have been off, but that kind of use was not a flagrant, excessive use. I can't really give the court a number. Maybe it's, you know it when you see it, but certainly in this case, 1 or 2 times as characterized by juror number 6.
But this 1 or 2 times was in the courtroom itself during closing argument?
Well, I believe that was during juror number 6. The questioning was not exactly precise. When juror number 6 was questioned about the cell phone use, she said 1 or 2 times, not that much, and not for very long, or words to that effect. When juror number 4 was characterizing the use in the courtroom, I don't think she actually saw that herself, and the trial judge did not inquire of any of the other jurors about whether they had seen any active cell phone use in the courtroom.
But ultimately, didn't the court say that it was discharging juror number 5 for failure to deliberate?
Yes.
So it wasn't maybe the alleged use of cell phone factored into the court's view that she wasn't deliberating, but what I have in front of me tells me that the court said although she had deliberated with other jurors, she's now of a fixed opinion, is not deliberating further. My question to you is, if a juror starts out deliberating, which I think some of the testimony said she had done, when does it become impermissible for a juror to say, I have my opinion now? I mean, when can the juror stop and not be discharged for refusal to deliberate?
When can the juror stop?
Well, I mean, it's a timing question. So you participate for a while, you evaluate the evidence, you think about it, you say, I'm persuaded of what I'm persuaded, and it's fruitless and pointless for me to keep engaging in this debate. Mm-hmm. I find it a very delicate, difficult question as to when that is cause for discharge and when that's cause for, just that a juror has considered matters and reached her conclusion. Yes.
Well, by all accounts, juror number 5 was deliberating actively at the beginning of the deliberations. A timeline of the deliberation shows that they deliberated the first day for 2 hours. That was a Wednesday, the 18th. They came back on Thursday They deliberated all day, 4 hours and 35 minutes. And it was on the third day, which was Friday, August 20th, that the notes were produced at the end of the court. Excuse me. But the jury deliberated for 4 hours and 17 minutes that day, and you could subtract 27 minutes of that for the post discussion with the court in the courtroom after the deadlock note had been submitted. So there was a significant amount of deliberations that took place. Juror number 4, who was the foreperson who I think the court gave credence to, described juror number 5 as engaged, articulate, actively participating, eager, not passive, animated, and engaging.
Counsel, that goes to one aspect of the issue, presumably, which is that juror number 5 was presumably part of that deliberation.
Yes.
But to take you back to Justice Werdegar's question,
Sure.
to the extent that part of the challenge before us is articulating a legal standard and applying a legal standard around how long a juror has to deliberate before it's okay for the juror to say, well, I've taken part in these discussions, I've been open-minded, I've had the back and forth before me, but I think I've circled in on my own conclusion. Is a juror entitled to get to that point before all other jurors have? And if so, at what point can a juror take a step back and say, if at any point, and say, I've reached a conclusion?
Well, it is a delicate question. I agree, and I don't know that I have an answer for an absolute time. I think it is clear in this case that not only had juror number 5 reached a conclusion, but perhaps also the remaining 11 jurors had reached conclusions as well. Because I am going to come back to your question, I promise, because it was indicated both by juror number 12 and juror number 4 that votes had been taken and that juror number 5 was a holdout juror.
So that's you could translate that by saying she refuses to deliberate because she won't agree with us.
I think it could be characterized that way, particularly.
At what point in time did the book reading and the cell phone use take place? Before or after the juror reached her conclusion?
I don't think the record
Or
really...
can you tell?
I don't know. The record isn't specific about that. There was a comment made by juror number 12 in the note that he wrote to the court. Unfortunately, the trial judge, when he interviewed juror number 12, he did not ask that juror any questions about the lengthy note he had written about juror number 5. But he indicated that she had turned to those devices when she stopped deliberating. But again, that was just something written in the note, and it wasn't followed up on. And the trial court did not direct that question to the jurors that he did interview.
Well, going back to the standard of review that the Chief Justice asked you about, so here we have a trial court who interviewed jurors and observed jurors, determining that a particular juror had refused to deliberate, and probably factoring in cell phone and book reading, but saying refused.
Yes.
What are we supposed to do with that? Conclude otherwise? I mean, that's what the trial judge on the scene determined.
Well, I think that the court does not necessarily have to look to the credibility findings that he reached about juror number 3. I think that this court has to look at the facts as they are on the record.
So you give us the facts from your point of view.
Well, I'll give you the facts from what the jurors' responses to the trial court's inquiry were.
Which he determined he didn't believe. He said, juror number 5's denial of so many things said by other jurors caused me to believe she's not being truthful when she talked about the use of the cell phone.
Well, that is true. The court did make that assertion. He did a bit of a comparison between the credibility of juror number 5 and juror number 12. This court really does not need to reach the credibility question, because even without considering the value of juror number 5's testimony and her answers, there is plenty of evidence to show that she was improperly discharged. First of all, the cell phone use and the book use, by all accounts from the other jurors, and that's all we have to go on. The judge was not in the deliberations room to view it, so all we had to go on were the other jurors' reports, and it was de minimis It was once or twice. Juror number 4, the foreperson, said she personally didn't even notice it. She was just reporting what another juror had told to her.
Can I ask you a question about
Yes.
just the overall schedule of the time that took to try the case and also the time before the jury reached its deadlock 2 days in after deliberations?
Correct.
So we have to evaluate whether or not the trial court abused its discretion in discharging juror number 5. And early on, we know that this case took 9 days to try, involved 38 witnesses, involved 3 charges of homicide, open counts that came
Right.
back as death verdicts,
Yes.
as well as 2 attempted homicides, as well as a torture assault on his former girlfriend, allegedly because he wanted to keep her quiet about his confession to her. And so after the jury received these 9 days, it's been in trial for 9 days and 38 witnesses later, 2 days into deliberation, the jury returned a note indicating it had been deadlocked. And I know that the court discussed that with counsel and then called the jury in and basically didn't give them an Allen instruction, but to the extent talked about their duty and sent them back. Later on, we know that it was the court's internal thoughts, thoughts that it put on the record, I believe, that it felt that a juror wasn't deliberating. Can we take into account, or does it shed any light at all on the fact that this case took 9 days and was witness intensive, involving 3 different crimes at 3 different times? Does that factor at all into our review as to, or what can we make of it, frankly, in the allegation that the finding by the court that the juror wasn't deliberating because it wasn't enough time? Somehow the juror must have, in other words, the juror must have at some point just stopped deliberating because there's no possible way in the judge's view that the jury could responsibly consider all 38 witnesses and what had happened here in 2 days.
Sure, and that goes for all of the jurors, not just juror number 5. The readback that was requested by the jurors before the deadlock note was issued by the foreperson concerned a readback of defendant Mr. Armstrong's testimony about the self-defense and the juxtaposition of the cars and such that happened when there was the murder on Century Boulevard. So it appears, if one can glean from what the jury thought processes might have been, that there was a juror who perhaps felt that the claim of self-defense that Mr. Armstrong had testified to had some credibility. So it was only after about 20 minutes after that readback took place that juror number 4 submitted the note regarding the deadlock. And then the notes from the other jurors, ensued after that, before they retired at 4:15 that afternoon. And it could be gleaned that juror number 5 perhaps had believed the testimony, but they, according to juror number 4, they had, I think her note, her deadlock note said that after extensive review and discussion of the evidence, we have come to the conclusion that we are deadlocked, or words to that effect. And then, as I said, the notes ensuing after that indicated there was a quote-unquote a holdout juror. So all of the jurors, it appears, had perhaps made their decisions. If you look at the second round of deliberations, after juror number 12 and juror number 5 were dismissed, the second round of deliberations actually only took 3 hours and 11 minutes. I counted every single one, longer than the deliberations of the first jury. And they came to the verdict that they came to, obviously, convicting Mr. Armstrong on all counts. I think it could be argued that had juror number 5 perhaps succumbed to the pressure it appeared she might have been under to change her mind, you might have had a series of verdicts in this case on the third day of deliberations. So how a jury deliberates, how they go through the evidence, what their thought processes are. Juror number 4 talked a great deal about testing the theories, and it sounded from her notes and her discussion that they really had gone through all of the motions and according to her and juror number 6, who had been a bit of a companion to juror number 5, that juror number 5 had deliberated, had all of the characterizations I mentioned a moment ago, and she had reached a conclusion.
Well, I see your point on that. Let me turn to the court's further observation. In addition and separately, the court determined that her failure to reveal that she had gang friendships expresses a bias on her part that she didn't disclose during voir dire. Could that uphold her dismissal independently of the so-called failure to deliberate?
No, because there was no evidence of her bias either, specific evidence of her bias either.
Well, I'm sorry, but what do you mean? There was evidence that
Well,
she had gang associations that
sure.
she hadn't disclosed. So the bias would be inferential, or?
Well, I'm not sure that I respectfully agree with
Sure.
Your Honor about whether or not she hadn't disclosed. Juror number 5 had been very forthcoming. A review of her juror questionnaire and a review of the voir dire that she underwent, very brief as though it was, indicated that she was very forthcoming. She said, I used to live, she did at some point indicate she lived on 104th and Crenshaw when she was younger. I think that actually was when the judge was interviewing her, which was actually the exact place where Christopher Florence's vehicle came to rest after he was shot. So she lived in the gang neighborhood. She told in the juror questionnaire and in the voir dire, or at least in the juror questionnaire, she said, I used to live in I used to live in a gang neighborhood. I went to high school with gang members. There's gang activity in my neighborhood, gang activity on my street. I know gang members, but I'm not friends with them. And in fact, she was quite thoughtful in her juror questionnaire about her life experiences having to do with gang members in particular. She was the one juror who did elaborate a little bit on the question about gangs. And she said, gang violence is stupid and senseless. Communities should do more to curb it. Gang life is all some kids know, and they need to be shown that there's more to life. But on the other hand, gang members must be held accountable for their actions and not be allowed to use their environment as a scapegoat. So this juror had thought about this question. She was, of all of the jurors, probably the one closest in age to the gang community, obviously had gone to high school and had friends who, not friends, that was not her word, but had acquaintances certainly. She'd seen gang activity in her neighborhood. These are the life experiences that we want our jurors to bring to deliberations.
So the court's conclusion, you're saying, is completely unsupported by the record. In fact, the record suggests contrary.
Well, insofar as juror number 5's representations, but also the court questioned juror number 11, who juror number 4, the foreperson, had said he was the one who had asked her to put in her original note that one of the jurors seemed to harbor some bias. And when you look at what juror number 11 said when he was interviewed, he was basically saying, well, I interpreted from her statements this and that, and insofar as gangs in particular, he said to the court, I think the statement was, I had or have a lot of friends who are or were gang members. And when the court asked him in what direction he felt juror number 5 leaned, he said, well, 4 gangs. And the court said, well, how does she express that? And the juror responded, well, she seems to understand how a gang member might react to a perceived threat. This is not a bias in charge of a gang. She didn't say, I will believe a gang member over anybody else. In fact, she very expressly in her juror questionnaire said she would not believe a gang member to the exclusion of anyone else. But I think that the bias that the jurors were, or the bias or the leanings that the jurors were discussing had more to do with the fact, I think, that juror number 5 had a sense from her life experience what might have happened at that that shooting on Century Boulevard. I am afraid I'm getting over my time.
You'll have 7 minutes for rebuttal.
Okay, very good. If I may, Your Honors, I just want to close for the moment and discuss what a really good juror number 5 was. Juror number 5 was 19 years old. She was a second-year college student at Cal State Long Beach. She had a very respectable job as a TSA baggage handler. She was very interested in this case. On the second day of deliberations, she asked the court's permission to take her notes and the jury instructions home with her so that she could review them, which she did. She watched the local national news, read the LA Times. She absolutely represented a cross-section of the community that we want to see on our juries. She participated, she drew a conclusion, she followed CalJIC 40 and CalJIC 41, which were in play at that time, to do exactly what she did: participate, engage, and draw a conclusion and not allow pressure from other jurors to change her mind. She reported the conduct of juror number 12 to the court, his meeting or realizing late in the trial that he was good friends with a relative of Mr. Armstrong's. Juror number 12 did not inform the court. It was juror number 5 who informed the court. So this juror was really punished for doing what jurors are supposed to do. And I would conclude that she was the kind of juror that we want on our courts, and she was not shown by a demonstrable reality to be unable to complete her juror duties.
You'll have 5 minutes for rebuttal, Ms. Scott.
Thank you.
Good afternoon, Your Honors. May it please the court. This case has nothing to do with whether Juror 5 was a good person, whether she watched the news, whether she read a newspaper, or whether she was a student. The question here is whether a demonstrable reality existed to show that there was good cause for her excusal because she was unable to perform her duties as a juror.
Counsel, do you agree that juror number 5 deliberated at least for some period of time?
We know that the record reflects that juror number 5 was stated to have been deliberating. But the record also reflects that juror number 5, when asked by other jurors to explain how she reached her conclusion, to discuss the evidence, she would not do so. And when the other jurors wanted to speak with her about different arguments, different evidence, she stated, I'm not a psychic. I don't know.
At what point in the deliberations did that take place?
We don't know time-wise exactly when it occurred from the record, unfortunately. But from the note from juror number 12 that was initially sent as an anonymous note, the record reflects that juror number 5 told the others to convince her, and that the reason the jury was deadlocked was because the other jurors were giving up as a result of juror number 5's behavior.
Okay, but here's the way this works. Each individual juror has to give their own best judgment about the case, right?
Yes, Your Honor.
And from what you just said, counsel, it sounds as though juror number 5 reached a conclusion about the evidence, based on the evidence, and then said, well, but if I'm wrong, convince me. That sounds like deliberating to me.
Your Honor, I would argue that if that's all that occurred, possibly. However, what the court learned from the jurors was that when asked how she reached her conclusion, she refused to explain how. That is not participating in the deliberative process.
Well,
and
what's the rule we should write? You're failing to deliberate unless you, what?
Well, Your Honor, if we look at Lomax, which this court decided in 2010, the rule was clear. It stated that an unwillingness to engage in the deliberative process occurs where the juror will not participate in discussions by listening to their views or by expressing his or her own views. Additionally, in Alexander in 2010, this court stated that it was a refusal to deliberate where a juror rebuffed attempts to engage the juror in discussions of other points of view raised by other jurors.
The evolution of this doctrine initially involved circumstances where jurors hid in the bathroom or sat in the corner and refused to engage at all. You go off and do whatever you want, the rest of you, but I'm not listening, I'm not talking, I'm not engaging. that's a fairly high standard. So it seems on this record that we don't have that sort of obdurate, I'm in my own little world, don't bother me kind of behavior.
Well, respectfully, Your Honor, what the record does show is that the juror was looking at her phone and looking at a book
When?
while the jurors were, well, during deliberations,
When?
Your Honor. I cannot tell you from the record the exact moment. What I can tell you is that the other juror stated to the court that she stopped participating in deliberations and was checking a phone and was looking at a book, which is not allowed. It's simply not allowed, and she was not participating when she was doing so. You cannot be listening to other points of view and actively engaging in deliberation if you're looking at a cell phone and you're looking at a book. It's just not possible. And additionally,
do we know how much of the many hours that they spent together deliberating, or at least in the same room together, this behavior to which you've made reference involved?
can you ask the question?
Yeah, that wasn't the
again?
best question in the world. Of all the time they spent together,
Yes, Your Honor.
do you have a sense of how much time she may have been looking at a book or checking her cell phone?
I don't have a specific time, Your Honor, but what I do have from the record is
Do you have a sense of proportion? I agree with you that if the juror retreats and is playing video games or doing whatever, that could be evidence of failure to deliberate. The juror herself said, well, occasionally I checked the time. Another juror said, I didn't notice her doing any of that at all. It seems as though it wasn't such a substantial proportion of the deliberative engagement that it rises to a level of dismissing the juror.
It doesn't change the fact, Your Honor, though, that other jurors stated that juror number 5 refused to explain how she reached her conclusions. And that's the whole point of deliberations.
Can you point me to where in the record we would look to find the allegations that the other jurors said that she failed to explain how she reached her conclusions?
Yes, Your Honor. It was the anonymous note that was sent by juror number 12. For the specific page number, if you give me a moment, please. Your Honor, it's in 18 RT 2922 through 2924 that discussion occurred about the note that was from an anonymous juror later identified as juror number 12.
So you're referring just to the note, not to the subsequent colloquy with juror number 12?
The note and then juror 4's having stated that they tried to get juror 5 involved in deliberations, but she would not get involved, that she wasn't open-minded. And the fact that she would not get involved goes straight to Lomax, which I discussed, where this court has held that rebuffing attempts to engage in deliberations is an unwillingness to participate in deliberations.
And number 12's note said what?
I'm sorry?
Number
please.
12's note said?
Number 12's note stated that juror number 5 would not explain how she reached her conclusions, instead told others to convince her. When the other jurors would ask what to talk about with her, she said, well, I'm not a psychic. And it was the belief of that juror that it was causing the other jurors to just give up on deliberations, that it was obstructing the entire deliberative process.
I'm sorry, so is that the part of the note that you're referring to about her refusing to explain her conclusions, is that on page 1022?
In the
referring
CT?
to?
Yeah, I believe that may be 4 CT 1022 through 1023 that has the actual note.
Okay. I'm looking at the note now, and I am not seeing anything to that effect, but perhaps I'm missing it.
Well, Your Honor, I believe that the note reflects that juror number 12 stated anonymously at that point that juror 5 wouldn't listen and was instead using a cell phone and reading a book and would not explain how conclusions were reached. Moving along, Your Honor, even if we were to find that juror number 5 was participating in an acceptable way in deliberations, it doesn't change the fact that there was a demonstrable reality that she would not follow the court's instructions. It was not an advisement not to turn on the phone. It was an instruction not to turn on the phone. And this court has held that where a juror fails to follow instructions, it's reasonable for that court to conclude that she will do so in the future. That
But
she
let
will
me
have,
ask
may
you
not
a
do
question.
so. Yes, Your Honor.
Under the demonstrable reality for removing a juror, we have to look at what the trial court said it relied upon and find that in the record. Did the trial court rely on juror number 5 not obeying the instructions on the cell phone in the book as a reason for why it discharged juror number 5?
Yes, Your Honor. The discussion that the court engaged in covered several points, and in it the court noted that she had not followed the instruction not to turn on the phone. The court also noted that she had concealed a bias. So although there is a final portion discussing a refusal to deliberate, the court did make these findings, that she had failed to follow instructions, that she had concealed a bias, that she had refused to deliberate, and that she herself was not truthful. The court specifically stated, I do not believe her. In addition, Your Honor, even if we were to find that the refusal to follow instructions wasn't sufficient, this court has held that a concealed bias is another reason that would support good cause for excusing a juror. Now, counsel would argue that juror number 5 concealed no bias. However, counsel specifically stated that in the, I believe it was the jury questionnaire, juror number 5 stated that she wouldn't believe a gang member over anyone else. Well, that's just not true. What the court knew from other jurors was that she stated that all cops weren't trustworthy, that all police were corrupt, and what's important to note is that during voir dire, she stated that, and let me be specific, she stated she had no bad feelings towards police officers, but that's completely inconsistent with what the other jurors informed the court she had said during deliberation. And that reflects a very serious bias that she was concealing, given that not only did we have a gang expert testifying who was a police officer, but we had testimony from other police officers. And the statement was not, I don't believe these particular police officers. It was all police are not trustworthy. All police are corrupt.
The foreperson had this to say regarding juror number 5. We would start to feel sort of a consensus going and try to integrate her into the conversation, but she seemed a little less open-minded. Do we know from the record approximately when this took place?
No, Your Honor. We don't. But again, what we do know is that other jurors had informed the court that she was not participating in deliberations, that she was looking at a book.
If we can't place a time on this feel of not participating, do we have enough of a record?
Yes, Your Honor, we do, because this is not a case like Bowers or Cleveland, where what we had was simply a juror who had felt differently about the evidence. What we had here were allegations of misconduct, that she was engaging in concealing a bias, in using a cell phone, in reviewing a textbook. That is much more than was present in cases
And I take that point, counsel, but if we could just leave those aside for one moment. I do acknowledge your argument there, and I do think that I see your point with respect to the cell phone use, for example. But with respect to deliberation, it seems to me there are some tricky questions here. Just to flag one, which we've talked about a little bit, but to highlight it, it's the question of what the trial court actually relied on in ultimately making this ruling. Because the trial court says, as you know, based on the testimony we've taken, what we've heard, which leaves it somewhat ambiguous. But the question I want to specifically ask you about, which follows on what Justice Chin was asking you about, is how long does a juror have to deliberate before reaching some preliminary conclusion and signaling to the rest of the jurors that that preliminary decision maybe has been taken? And how do we know that that period of time didn't run here?
I think that's a great question, Your Honor. And it points to the delicate balance that the trial court had to maintain here in its inquiry. It was faced with very serious allegations about what the juror was doing. And as we know, a trial court has to maintain the balance of not invading into the deliberative process and potentially coercing a verdict. As to your question specifically, there is no specific time limit. But what there is the need to be willing to engage in discussions, the need to be willing to explain your positions and how you reach them. And when a trial court is faced with other jurors stating she's not doing that, we don't have what it means to be a juror deliberating.
Well, it's one thing to make a sweeping statement that she's not explaining herself. Are we at this great reserve from the trial just obligated to take that at face value now? Doesn't the trial court have an obligation before it engages in such a drastic action to inquire exactly what's happening? If a juror says, you know, I've listened to all your points, I just don't find these witnesses convincing. That wouldn't constitute a failure to deliberate, would it? Or a failure to explain why you've come to the conclusions you've come to?
That's true, Your Honor. With all due respect, I don't believe that's what we have here on the record.
How do we know?
We know because the court...
We don't. That's a problem.
I disagree to some extent, Your Honor. Juror number 4 stated that juror number 5 seemed unable to weigh the evidence and to make decisions. That's very serious. That goes to deliberation if you're not capable of weighing the evidence. Juror number 6 confirmed the remarks that juror number 4 had already made about juror number 5 and her inability to deliberate. In addition, juror number 11 confirmed that juror number 5 had concealed the bias, stating that she had distrusted police officers. My point being, it cannot be said from this record that it reflects that all that happened was a juror having weighed the evidence, explained her position on how she reached the conclusion she made, and then not being able to be moved off her position. Instead, we have a situation where a juror would not participate and would instead look at a cell phone, review a book.
That's the best you've got? That's where you want to put the strength
No, Your
of your
Honor.
argument, on the cell phone and the book?
Your Honor, I'm talking cumulatively about what occurred in that deliberation room, including a concealed bias that was very serious about not trusting any police, that all police were corrupt. Your Honor, it can't be said you're fairly deliberating if that's the thought process you're going. You are not going on evidence at that point. You're going on a preconceived notion about all police officers. That has no basis in the evidence, and that is not participating in deliberation. Your Honors, I would argue that there was a demonstrable reality that juror number 5 did not show that she was unable to perform her obligations. What we have here is a trial court who was faced with a situation of allegations being presented. And then the question is, what was the trial court obligated to do? And then based on what it did, was it permitted to reach the conclusion that it did? Faced with these allegations, the court was well within its discretion to conduct an inquiry into what had occurred. The court spoke to several jurors. Several jurors corroborated each other. And the one juror that didn't corroborate was juror number 5, who the court flatly discredited. So, Your Honors, with all due respect, the evidence shows that juror number 5 was unable to perform her obligations. And
Counsel, doesn't this, I mean, I appreciate what you're trying to do to distinguish the situation of a, let's call it a legitimate holdout juror. But it's very hard to tell the difference, because in any holdout situation, couldn't the others always complain that this holdout just is unmovable? Because by definition, I mean, at the very end, whether it's 2 days or 2 weeks, the person has reached their judgment and the others disagree and cannot move the other person, perhaps can't even understand why the other person thinks what they think, and you could have the exact same record as appears in this case. How are we to tell the difference?
Well, Your Honor, because here we have no evidence of jurors complaining that she did not agree. And the court never received a numerical split nor asked for a numerical split as to how the jurors were finding in terms of guilt or innocence. What we have here is the jurors coming in and stating she won't deliberate with us. She won't explain her position. She won't tell us what we can speak with her about. And she's looking at a book. She's looking at a cell phone. And she's raising serious biases that were never disclosed that we think are contributing to the conclusion she's reaching in the jury room. So it's not a situation
Did the court inquire about that asserted bias against a class of witnesses?
Did the court inquire about it?
Did the court ask juror number 5 about it?
Your Honor, with respect to juror number 5, the court specifically dealt with first the phone and the book, and then did go to the bias, and she denied having any bias. She denied having a bias regarding gangs. She denied having a bias regarding police officers. So yes, and the
So
court...
then it was a credibility determination.
Yes, Your Honor.
You have one juror saying she believes all police are corrupt, and she thinks it's hard to persuade a person who believes all witnesses are lying. And then that's what one juror says about her, and then she says, no, I have no bias. So it is a credibility determination.
Yes, and this court has held that the issue of concealed bias is often a credibility determination, because typically the biased person is going to say, I'm not biased. And so this court has held, and I believe it was in Barnwell, that sort of credibility contest is often left to the trial court.
If the court states as its reason for discharging the juror her failure to deliberate, that can subsume what the court might have concluded was her bias against the prosecution witnesses, could it not?
Yes, Your Honor, and I think it's quite clear that was subsumed because the court made the specific findings that she was concealing a bias, that she didn't follow the court's instruction not to use the cell phone. So yes, I do believe, Your Honor, that all was subsumed.
So my understanding about the trial court's ruling is that it focused primarily on the failure to deliberate. And then it turned to separately, and it says in addition it talked about bias. But it didn't talk about bias against prosecution witnesses and didn't mention, I understand, that the police were corrupt, et cetera, but talked about the gang member bias, correct?
Yes, Your Honor.
And so we have to rely on what the trial court relied on, which is the gang member bias.
Yes, Your Honor.
Which Ms. Scott indicates was not evident. She had been forthcoming about her experience with gangs in the neighborhood, but
Yes,
that
Your Honor.
nothing had been concealed. What's your response to that?
First of all, Your Honor, I would say that they are not two separate issues, feelings about police and feelings about gangs in this situation. Because this was a case where there was an argument being made that the police had coached two witnesses to testify against the gang
I'm not sure I
members.
necessarily disagree with that, but I think by the heightened standard of demonstrable reality, we're stuck with what the trial court said, not what we can imply from what the trial court said.
Well, Your Honor, again, juror number 5 stated before trial in I believe it was the questionnaire in voir dire, that she wouldn't believe a gang member over anyone else. However, that's clearly not true. From what the court learned, she stated she did not trust police and all police were corrupt. So obviously, she would believe a gang member over someone else, and that is a bias. Clearly, it shows that she had a bias over
But
gang
what did the
members.
trial court rely on? I mean, what exactly did the trial court rely on?
The trial court relied on what it had learned from all of the jurors about being told that juror number 5 had said all police were corrupt, that they weren't trustworthy, and the remarks about understanding the minds of gang members and associating with gang
How do we
members.
know that the trial court relied on the anonymous note that turned out to be from juror number 12?
How do we know that the court relied upon it?
Yes.
Well, we know that the court conducted an inquiry and spoke and reviewed all these notes and spoke with all these jurors. That's the record that was before the court. And the question is whether that showed a demonstrable reality.
But what's the, okay, I understand that, but what's the best site on the record to suggest that part of the thinking of the trial court pivoted on the note?
Well, the court noted that it had reviewed all of the discussions and all the notes, and it stated, while I understand that it didn't expressly state this particular note, it certainly was making its findings based on the entirety of what it had heard, because it then moved on to discuss juror number 12 as well. So I think it's quite clear that the court had reviewed everything. It wasn't excluding any particular note, and it was considering all the
problem
evidence.
with juror number 12. First of all, the note's anonymous. Secondly, juror number 12 himself was excused for misconduct, an action to which the prosecution assented. And when the court had the opportunity to inquire of juror number 12, it didn't ask juror number 12 anything about the note.
That's correct, Your Honor.
Or about juror number 5's conduct during deliberations.
That's correct, Your Honor.
So are you suggesting that this anonymous note from a demonstrably misbehaving juror is what gets you across the finish line?
I'm suggesting that all of the court's inquiries and all of the notes together form the basis of the court's opinion. With respect to juror number 12, what I think is important to note is juror number 12 didn't deny having the relationship with appellants. I believe it was appellant's cousin. Didn't deny having spoken to anyone. There was no dishonesty there.
Didn't bring it to the court's attention either.
That's very true, Your Honor. That's very true. And juror number 12 was excused, and the court did conduct a sufficient inquiry into juror number 12.
Just suggesting juror number 12 is an awfully slender reed on which to lean.
And even if we don't lean on juror number 12, Your Honor, we still have juror number 4, juror number 6, and juror number 11, who all corroborated each other, saying that juror number 5 was not.
I take that point, counsel. Let me go back to something that Justice Liu was asking you about, which is about how a juror is supposed to appropriately disagree. And the reason this matters, of course, is because juries do hang, and part of the protection the criminal justice system offers to defendants is that the jury can hang because the jury has to be unanimous. What's the proper way for a juror who is disagreeing continuously after some amount of time to signal that the juror is still unmoved and does not believe it likely that the juror will be unmoved?
I think it's impossible to announce a specific factual scenario that answers your question, but what I think is possible is to say what is not acceptable in response to your question. And that is, it's fine, Your Honor. There's no argument that the case law has held that it is fine for a juror, even based on faulty logic, to reach a conclusion, so long as that juror has participated in the deliberations. However,
Has participated
has
past
participated.
tense.
However, there is no case law that says a juror who's looking at a phone and looking at a book and rebuffing attempts to be spoken to qualifies.
But this
as
juror did
deliberation.
participate, though. I mean, I think
I'm sorry, Your Honor?
this juror did participate, though. I mean, that's what the evidence indicates.
The evidence is that the juror at some point was participating in deliberations. The evidence, however, also was, and I can specifically note, if this court is not satisfied with juror number 12's position, juror number 4, who said that she was not able to weigh the evidence and make decisions. So I don't think the evidence shows that she had fully deliberated. I think what the evidence instead shows is that she had not deliberated
Can
at
I go
all.
back and ask you something the Chief Justice asked at the beginning about the standard of review? And I was trying to get to this in asking you, what did the trial court rely on? Our precedents say that we are here reviewing under the demonstrable reality standard, not what the trial court could have relied on, but what it did actually rely on. You agree with that, right?
Yes,
I mean,
Your
that is
Honor.
what. So it's not enough to just say, well, the trial court heard everything and then issued a ruling. We have to have a statement of reasons of some sort, don't we?
Yes, Your Honor.
Okay, so what exactly is in the trial court's statement of reasons here? I mean, it's not everything, right? So I want to sort of understand just the portion that we are reviewing here, and we're not reviewing everything that was said at the hearing.
Okay, well, Your Honor, after having heard from the selected jurors and having no request from counsel for any additional jurors to be interviewed, the court first noted to counsel that it had specifically instructed the jurors that they were not permitted to use their cell phones in the jury room and were to turn them off. And the court added that jurors were required to at least listen to each other during deliberations. So we know that the court considered what it had heard on those 2 points. Turning to the individually interviewed jurors, the court noted that from its own observations during trial, it believed that juror number 5 and 6 were friendly. But despite their friendship, even juror number 6 felt that juror number 5 refused to participate in deliberations. And juror number 6's account of juror number 5's behavior was consistent with juror number 4's account of it. So from all of these accounts, the court then stated that it was concerned that juror number 5 was not deliberating and was concealing a bias in favor of gang members and against police. And we know that from 18 RT 2977, where the court made its finding. Then the court went on to discuss juror number 12 in the separate issue regarding the relationship that juror number 12 hadn't disclosed, which became known to juror 12 later on once the trial had already started. Additionally, as to juror number 5, the court then went on to conclude that juror number 5 has already reached a conclusion and is not deliberating further, and that's corroborated by the report from juror 4 that she has on, and the court states, a couple of occasions, at least looked at a textbook and checked text messages, leaving her cell phone on, which is in direct contravention of the court's instruction, and that's at 18 RT 2980. Then the court commented on juror number 11's statement that juror number 5 said she had friends who were gang members, and the court also found that the evidence tended to show that juror number 5 was biased in favor of gang members. That's at 19 RT 2980. More importantly, the court found that juror number 5's statements lacked credibility. Her statements being denying everything that she was being accused of by all the other jurors. So we know that the court relied on all of that in reaching its finding. If there are no further questions, Your Honor, I'm prepared to submit on my brief, and I ask that this court affirm the judgment with the exception of the correction that both parties discussed about the abstract of judgment. Thank you, Your Honor.
Thank you.
Counsel, what should we do with the serious assertion that the juror was not evaluating the individual credibility of each witness, but was finding a group of people as a body not to be believable? Specifically, all policemen lie. It's one thing to say, I didn't find these policemen credible. That's a juror's job. It is not acceptable for a juror to say, I refuse to consider the testimony of anybody who fits in this class, whatever the class is. So, and there is that assertion in the record. So what should we do about that?
Well, that assertion is in the record only as to the juror, well, primarily as to the note from juror number 12, which also has been referred to as the anonymous note here. And as was pointed out earlier, juror number 12 was never challenged directly on any of the assertions that were made in that note by the trial court. He instead went on to discuss the cousin. But to get to your question, the only indication, the only reflection in the record having to do with the police officer in terms of being one of the jurors being interviewed was juror number 11. And this was the juror that seemed to be of that opinion. And he indicated that she made statements that he interpreted to indicate a distrust or suspicion of police, to the effect that police can coach witnesses to tamper with manufacture evidence. And he indicated that there was no specific claim made by juror number 5 about the case, but that he surmised it had entered her mind in connection to the two surviving gentlemen that were in the car on Century Boulevard, that their testimony was consistent with the police. But that's really a non sequitur here, because Mr. Armstrong, the defendant, did take the stand and acknowledge that he was the person who fired the gun. So there really wasn't a question about police distrust. It wasn't as though we had interviews with the defendant or we had circumstances where the credibility of the police officers were at issue. It was the police testimony was primarily about the investigation that was taken, and there wasn't a great deal of controversy about the bullet casings and the investigation itself.
Counsel, does a juror have a right to say that the juror disagrees without explaining what the evidentiary or legal basis is for that disagreement?
Well, it's certainly better if a juror explains the basis for his or her disagreement, but we don't really have a record that says that she did not explain her disagreement.
I understand that point, but work with me on the legal standard.
Okay.
There are many arguments you can make and have made about what the record shows and doesn't show here.
Sure.
There's also a question about exactly how to interpret the case law and apply it here. Mm-hmm. So in thinking about this question, what is the responsibility of a juror to say, this is why I disagree, this is why we're heading towards a hung jury, because of these 5 reasons or these 3 reasons? How much of a responsibility is there?
Well, I would think that if a juror is expressing a conclusion, and as in this case, apparently a conclusion that was contrary to the conclusion of the other 11 jurors, certainly it would be helpful to express why. I really can only go on this case because I think it was fairly obvious that juror number 11 might have believed the testimony by the defendant, because, as I said, the deadlock only was announced 20 minutes after the readback on that testimony was given. And I've just lost my train of thought.
But it sounds
I'm sorry.
Well, it sounds like what you're alluding to is that even if there is even if it is important for the jurors to understand the basis for the disagreement from the holdout juror, let's say, right, it could be that they could infer it from the circumstances of the discussion rather than waiting for that particular juror to explain it.
Well, if I may, Your Honor, thank you. Juror number 4 did, during her interview testimony with the trial judge, did say that juror number 5 was not passive, that she saw many possibilities in the evidence. They worked through the counts, but they all seemed to be related and came back to the same the same center. She had her own feelings and perceptions. The juror said, "We've tried to change her mind, but our discussions and means of getting to the truth don't hold water when she's engaged, she's animated and articulate." And then she finished off by saying the jurors are frustrated and they don't want a hung jury. And just getting back to juror number 12's note, to the credence that it deserves. Juror number 12, the initial part of his note was, "We wanted to let you know that we, 11 other jurors, are having a problem with juror number 5. She's the reason we are a hung jury. The way things are now, we will not be able to come back with a verdict other than a hung jury. Jury. Our other jurors have given up on trying to persuade. A lot of them are in a hurry to get back to work. We're hoping you can do something to help us out." I don't think there's any indication that juror number 5 was not sharing with the rest of the jurors what her perceptions were in this case. How to extrapolate from that as to what is the limit for a juror to explain his or her positions, I think every juror is obligated. And this court held in People versus Cleveland that a juror who does participate in deliberations and at some point reaches a point where that juror has made a decision, it is not a ground to discharge that juror simply because she says no other viewpoints or argument are going to change my position. And that's exactly what CalJIC 41 says, or CalJIC 40 says, and it's exactly what juror number 5 did.
Your time's expired, Ms. Scott.
Thank you.
Thank you, Ms. Scott. Mr. Cohn, the matter is submitted. Calling the matter of People versus Brandon Lance Reinhardt. You may proceed.
May it please the court. Good afternoon. When Congress enacted the Mining Act of 1872, it explicitly envisioned a role for state and local laws. The purpose was to encourage mining that complied with federal, state, and local laws. And so for more than 100 years, California law has affected mining and its profitability. We banned hydraulic mining. We tax mining claims. We have a whole host of laws that affect mining's profitability.
Counsel, your theory of the statutes here and their purpose presumably nonetheless still implies some acknowledgement that there are limits on what the state can do. And if so, what are those limits?
The limit is that the state cannot enact a law so that it's impossible to comply with federal law and state law.
That it's impossible to comply with federal law and state law.
So you're suggesting that there's no purposes and objectives preemption claim that is possible with respect to the Mining Act of 1872?
No, I don't mean to go that far, but the purposes include, the full purposes of the statute are to not only encourage mining, but also to allow states to regulate mining.
Well, if you're encouraging mining, but the state precludes the only viable method of mining, how does that work out in your theory? Well, that's the postulate of the case here, that although he had the right to mine, the environmental regulations precluded his using the suction method, and he argues that's the only method that was feasible.
He argued that it was the only economically feasible
All right.
to mine. It's certainly possible for Mr. Reinhardt to mine his claim. He can mine on outside of the river. He can also mine using non-motorized methods. They might not be as efficient. He might not make as much of a profit, but he can certainly mine.
So your position is he has a right to mine. He doesn't have a right to mine in a given way.
Correct. That's correct.
Does it matter at all how practicable or not the available methods of mining remain? So if his only available method is to take a sort of a garden shovel and dig in the dirt, that's the only thing that state law would permit him to do, is that a problem from a federal preemption standpoint?
I don't think that flows from the language in the statute or from what the federal agencies have talked about here. So I understand there may be some unease with that proposition, but the statute here doesn't make distinctions other than whether the state law is inconsistent with federal law.
And when you say the statute here, you mean the Mining Act, but what's your sense of the relevance of the Multiple Use Act?
You're referring to the statutes enacted in 1955.
Correct.
We don't believe that Section 612B, which is what Mr. Reinhardt has focused on, is relevant at all.
Why not?
Because it only refers to limits on the United States, its permittees, and its licensees. There's no reference to states at all. And in fact, 612 is followed by 613, which 613 lays out the process for resolving conflicts between miners and the United States. And it talks about federal agencies and has no reference at all to anyone but the federal government.
So I guess I'm trying to understand why you would draw the line in the place that you're suggesting the line should be drawn. So it sounds like you think that it would be a problem from a federal preemption standpoint for a state to ban mining altogether within a claim under the Mining Act of 1872, but it's okay for a state to effectively ban any form of mining that might actually yield a product. I mean, is that an accurate characterization of your position? And if so, how do you draw that line, looking at the text and the purposes of the Mining Act?
Well, I think there's a couple reasons to draw the line there. 3 reasons, at least, that I can think of. So the statute speaks to laws that are inconsistent with the laws of the United States. Okay? And inconsistency to the common person is the same as a conflict. That's a bright line to draw. If we draw the line somewhere else, then we're going against the presumption against preemption, which asks us to interpret preemption in the narrowest way possible. We're also not giving enough credence to the federal agencies who have come to that conclusion. And perhaps most importantly, if we draw the line at some place that's like economic practicability, we run into all sorts of problems. The price of gold has fluctuated wildly over the course of this litigation and in the past 10 years. Different miners have different abilities. Different places have different amounts of gold. And if we have a standard that's as subjective as economic practicability, then we have a situation where preemption depends on whether it's 2003 or 2010, whether I'm mining the claim or an experienced miner is mining the claim. And that is not something that Congress intended, certainly. And so I think all those things point to us wanting to have a bright line rule here.
Do those arguments suggest that the Lawrence County case was wrongly decided?
I think the Lawrence County case, I personally think it was wrongly decided, but I also think it's very distinguishable
How so?
because it was explicitly a local zoning law. So it was a county, and a small portion of that county was prohibited from any mining. Here, we have a statewide law that applies throughout the state. It's in no way a local zoning ordinance.
And why does it matter for purposes of the analysis whether it's a local ordinance or a statewide law? If the question at the end of the day concerns the quality of and degree of interference with mining under federal law?
Well, because Granite Rock has a great amount of dicta talking about it's important to make a distinction between those two. That's why it matters.
And what is the reasoning underlying the distinction?
Well, I think it's important to make that distinction because we're dealing here with federal land, right? So it's appropriate for federal agencies to make decisions about whether land is used for housing or commercial or mining or something like that. But in contrast, when you have an environmental regulation like this is, that focuses on the significant environmental effects, then you're back in the wheelhouse of the states. The core police power of the state is to protect fish and wildlife, water quality, its citizens, and so environmental regulations fall within that scope, and the court should be more deferential of that.
Is your position, counsel, that there really is no obstacle preemption of the Mining Act?
No. But I think obstacle preemption depends on the purposes of the statute.
If you say that the purpose of the Mining Act is to sort out title and possession to lands that are available for mining, subject to compliance with state, local, and territorial law, isn't that kind of a closed loop there? I mean, you can never really have any obstacle preemption because no matter what the state, local law is, it'll always be caught by that purpose. Other than the express carve-out for laws that are in conflict with laws of the United States governing possessory title, right? But the whole panoply of environmental regulation or any other kind of regulation seems not preempted, even if it deprives the possessor or owner of all economic value related to mining of that land.
I think that's what Congress intended.
And what's your best evidence for that? Congress having that particular purpose in mind?
That from the language of the statute and from, remember, the history of the Mining Act. The Mining Act was enacted after California's Gold Rush. And California's Gold Rush was the Wild West, right? And local groups in the state set up their own rules and regulations. And Congress meant in 1866 and then in 1872 to leave those in place. And I don't think I need more evidence than that. I mean, the language of the statute is, this court has held in Viva, the language of the statute is the best evidence of Congress's intent. Getting back to your question, it may be that the sliver of obstacle preemption over and above conflict preemption is very narrow. It may be true, but that's due to the language that Congress enacted. And there are cases that speak to when Congress has enacted specific language, do we go past that to imply preemption? And sometimes we do, and sometimes we don't.
Well, I think it's fine. I mean, as a possible position, I'm just wondering what your position is.
Yes.
I mean, is there any obstacle preemption available here? I'm just wondering what the breadth of your theory is.
Oh, I think in this case, there is no obstacle preemption.
I know, but where does that take us? I mean, is there ever any possible obstacle preemption?
It's hard to think of a situation, but I think there could be. I think there could be.
How could it ever come up?
Well, I mean, for example, if California passed a statute that said no mining of any kind is allowed in the entire state, that I don't see that happening. We have plenty of statutes that encourage mining here in California, but that might go so far as to, pass that line.
Under an obstacle preemption theory or under a conflict preemption theory?
It would be an obstacle preemption theory, because there's nothing in the Mining Act that requires any miner to mine, right? They can claim a mining claim, they can do maintenance work, they can pay their fees, but they don't have to actually go on site to continue to hold that mining claim.
So why would it be that a state law that bans mining altogether would pose an impermissible obstacle to the achievement of the purposes underlying federal law, but a law that bans most forms of mining, all forms of mining that would make it worth anybody's while to mine, would not pose the same type of obstacle?
Because when Congress enacted the Mining Act of 1872, it gave miners the opportunity to go on federal land and seek gold, but it didn't guarantee them that. It didn't guarantee they'd find anything. It didn't guarantee that they would find enough to make profit. It encouraged them to do it, but it didn't.
Counsel, as I understand it,
Sorry.
your argument is that the federal law does not preempt the California law that's coming out of California's concern with the environment. Do you want to elaborate on that, or is that the beginning and the end of your argument?
Well, I think Mr. Reinhardt has conceded that California can adopt what he calls reasonable environmental regulation.
And does he concede, I'll hear from him, but that this is reasonable environmental?
No, of course, he characterizes it in a way that's unreasonable, but I think it's quite reasonable what the legislature did here.
So is what you have to argue against the idea that because banning the suction method removes any economically feasible or commercially feasible method of mining, that it's preempted? Is that what you have to defend?
No, we didn't ban suction dredge mining.
I'm sorry, I can't hear you.
I'm sorry. We did not ban suction dredge mining. We placed a moratorium on it for a period of time while an environmental review was proceeding.
So what's the difference between banning it and establishing a moratorium, other than that there's a moratorium could come to an end, but as long as the moratorium is in place, it's banned. Isn't that right?
Right. A moratorium can be characterized as a temporary ban, certainly.
So I'm not sure that assertion is compelling as an answer to Justice Werdegar's question, to say, well, we didn't really ban it, we just established a moratorium. I don't think that gets you there.
Well, it may be that I didn't understand Justice.
May I ask you the question without, I remember reading it, but I want to hear from you. I know the legislature had and gave great consideration before it imposed the ban/moratorium. So and I know that the state acted in a way to regulate protection and public use. What did it find, the state find, were the dangers of suction mining? Why do they need to conduct an environmental study of such a thing?
The reason that this environmental review was done was because suction dredge mining is, what it is putting a vacuum in the bottom of a river and sucking the gravel and the rocks and the dirt out. And what that does is it affects the habitat of fish. And specifically what caused this environmental review to happen was that there were threats to endangered salmon in Northern California. And the concern was that that was affecting, that suction dredge mining was affecting those endangered fish. So there are those concerns. There are also concerns because suction dredge miners target areas that were mined previously. And California has a history of using mercury to mine. And so there is mercury in the sediment in the rivers that we have where these fish live, but that also flow to San Francisco Bay, that when suction dredge miners do their work, they pull all of that mercury out, and it ends up in sediment in the water column and flows down to where people live.
Which is your argument that this is quintessentially a police power exercised by the state to protect the environment, and that the Mining Act from 1872, enacted after the gold rush, as you said, the Wild Wild West, to encourage mining and settle property expectations, never meant to displace the state's inherent sovereign authority to regulate the environment of its land and waterways for public use.
Yeah, I agree. And there's further evidence after the Mining Act of 1872. California banned the mining method of hydraulic mining, and Congress took notice of that. It knew that it affected all those businesses, and it, instead of affecting that ability to ban hydraulic mining, it set up what was called a debris commission to further regulate hydraulic mining. And so that's further evidence that Congress didn't intend to upset this police power.
You've mentioned the text several times, going back to the preemption discussion, and I certainly accept and believe that the text can tell us a great deal about what the legislature is trying to accomplish. But help me zero in on the text that you think is most helpful to your position.
It's the phrase, under regulations prescribed by law.
Got it. So your argument is that piece of the statute is underscoring that what the legislature is trying to accomplish here is to protect a sphere of police power for the state.
Yes, because the word law is normally meant to include federal, state, and local laws. And that's also emphasized by the last phrase, which says, so far as the same are applicable and not inconsistent with the laws of the United States. So laws in comparison to laws of the United States, the difference underscores that that's meant to protect state law.
Do you see Section 21A of Title 30 as being relevant in terms of considering what the operative purposes of the federal statutory scheme are? Should it play a role in our consideration of this issue or not?
Certainly. I mean, the United States filed an amicus brief in this case, and they made the point that this provision, as well as other federal laws, recognize that the environment is part of the balancing, and that mining isn't to be encouraged at all costs, that there are environmental needs, that's the phrase that it uses, that need to be taken into account as well under the Mining Acts. I've lost track of time, but I think my time is
Your
up.
time's expired. You'll have 8 minutes for rebuttal.
Thank you.
afternoon, Your Honors. You all issued an opinion in December in the Quezada case, which discussed federal preemption at quite some length, and we didn't have an opportunity to brief it. But one of the things that you said is that the court should not lightly infer an intention to negate the state's exercise of sovereign power. And one of the things that you said is that that's based on a respect that sovereigns have for each other. And so what I'm here today to urge you is that respect and comity are a two-way street. And that what is going on here is that California is totally disrespecting the federal policy. And to get to that point, I want to push very deep into what that policy is. And I want to do a quick run through all the statutes. We've talked about Section 22. He's mischaracterized it. The part about regulations under law referred to mining districts. It was regulations of mining districts, and the so far as not inconsistent is a straightforward adoption of obstacle preemption. There's a large body of authority construing this. There are other sections of the mining law, I think in 3035 and so forth and so on, which talk about state law, the state law related to the acquisition of title, miners fighting over claims, all this kind of things. There's a role for state law, but even going back to the turn of the century, it was always the law that whatever the state did, to quote the Butte City case, it could not interfere with the liberal spirit of the mining laws. Now, later we come out to sections...
It remains the case, does it not, that the state has not banned mining. The state has said you just can't mine using this technique.
I would agree that it is true that Mr. Brant Reinhardt can still use a teaspoon. He can use a gold pan. But this gold is underwater, and you can't breathe underwater without equipment using motors. It places the valuable minerals in his claim completely off limits. What's more, there is no factual record before this court.
Well, suppose somebody decided that the best way to get gold out of a river is to lower a depth charge. Because, that'd blow gold right up into the...
I got it. That's what the law professors say. We can have an atomic bomb to dig these things out.
I wouldn't go quite that far, but help me with the depth charge example.
Okay, the depth charge example is that we have a large body of case law on what reasonable environmental regulation is. We have the case of United States versus Richardson. You're not allowed to use dynamite unless it's really, really necessary. So in that case, they told the miner, you can't use dynamite, you've got to use this core drilling method instead. The courts have developed a body of law over 100 years to narrow and protect environmental values on the federal regulatory side.
But to pick up on Justice Corrigan's question, what aspect of the depth charge problem or mining activity in general can the state regulate under your theory?
Under my theory, it can do what Granite Rock told it can do. It can have reasonable environmental regulations that do not interfere with the federal policy. And what is missing so far, and what I really want to try and hammer home today, is the nuances of that federal policy. Because when you march through all the statutes, you'll see that there's a fundamental difference and inconsistency between the federal view and the state view. And I'll just jump to the end before I go back, which is the federal view is the minerals are there. They're in a place, okay? They're not anywhere else. The only way you can get the minerals out is by taking them out of that place. And you can't take them out of that place without causing some environmental impact. It's inevitable. And so the whole structure of federal law, not just the statute we've discussed before, but the Federal Land Policy and Management Act, the Forest Management Acts, all of these statutes talk about unnecessary and undue degradation. This may be analogized to what you have in CEQA. In CEQA, you have a circumstance where an agency in California wants to do something, and there's significant environmental impacts. And the agency can do what's called a statement of overriding concern or something like that, where the thing says, okay, we understand there's significant impacts, but the policy is we want to do this for policy reasons. And that's what Congress has said for minerals. We have a statement of overriding concern because of things like 21A's national security, industrial needs, this need for stable mineral industries, all these things that are destroyed by moratoriums. We have overriding policies here. And what happened instead? The state comes in and says, we've got environmental laws, we've got water quality laws, we've got air quality laws, we've got disposal laws, but these laws and the standards that are in these laws, the reasonable environmental standards, they can't stop the mining. And we don't like the mining. We just want the mining to stop. And we've got to pass a new law that says we're going to prohibit it.
Okay, that's a lot. How do we, as a court, cash out the principle of reasonableness that you want us to apply here?
You look at 612, and you look at the federal statutes that explicitly give authority under the water pollution control standards. Things like water pollution control standards are right there in the federal law. You can do that. And there are standards, but the standards don't bar this activity because this activity is so utterly insignificant that it doesn't violate the standards. That's what's really going on here.
So-
Do you take the view that
Instead, we
it's
have to switch to a prohibitory approach instead of an approach of reasonably addressing the environmental effects of the use. And that's what we say
I
we
guess
cannot do.
you're asking us to essentially second guess the agency's determination here of both the potential harm of suction dredge mining and then the proper way to go about ameliorating those harms.
Well, I got a better argument than that. The better argument than that is that under the obstacle theory, what the state's motives are essentially functionally irrelevant. You said that in this Martin case, that's in Medtronic. What we look at is the federal objectives and whether they are interfered with. And the federal objective is to have this overriding policy that says sometimes we're going to have some significant effects. And we can't have a state statute that says, oh, you've got to fully mitigate every effect we can think of. And the history of that provision indicates that it's expressly designed as a prohibition.
What about the early, the late 19th century ban on hydraulic mining?
Yes,
That seems even.
He's wrong. He's wrong. They didn't ban hydraulic mining. You want to know what that statute says? The Public Resources Code, Section 3923 or whatever, it says, the business may proceed so long as there's no material injury to these lands downstream. Because this was real harm. This is like the whole river's it's washing out bridges. It's covering thousands of acres of farmland with rocks. These are effects that are miles away, and it was an attention to environmental effects on a specific case-by-case basis. It was early environmental regulation.
So you're going to argue. You're going to argue with your opponent here about whether or not the dislodging of mercury into waterways that go into people's houses is or is not sufficiently harmful?
Of course, because what he didn't tell you is mercury is like gold. It winds up in the dredge, and they take it home. And what they're fighting about is there's this 1% little piece that goes back in and falls back where it was, and some of it might drift a little further downstream. Other states, they run these programs, which is let's have the dredgers help collect the mercury. The papers that they have written on this thing they are fraudulent.
So, counsel, is there any factual circumstance under which a moratorium on suction dredging would count as a reasonable environmental regulation as you understand it? Any fact pattern, any scenario?
Not where it has been underway for decades without killing or hurting anything, and the federal agencies are essentially expressly authorizing it. Because that's what we got here. We put in the record the Forest Service decision. The guy comes in for his Forest Service approval. Forest Service comes back, where's your California permit? He said, well, that's not reasonable. They won't grant one. Forest Service takes it out. Well, we're regulating, it's fine. To answer your question, maybe if you had this new method of mining, okay, nuclear bomb method, all right, and somehow the federal agencies were all asleep, and somebody said, well, the nuclear bomb method is so wild that, maybe we should study it, and the feds didn't say anything. But that's not what we got here. We had a functional system in place for decades, and nobody ever got hurt. There were no dead fish. There were no sick people. There were no traces of anything anywhere that could be measured. There is nothing. And
doesn't the regime have to leave space for the state to be able to study whether or not the effects are as minimal as you say, or more on the nuclear bomb scale?
Sure, it can study. It's
So
been studying it for years. It studied it for years before the moratorium.
So at what point, in your view, does it become impermissible for the state to study those environmental effects? What's the difference between permissible studying?
Nothing ever stops the state from studying. What we say the state is not allowed to do is enact what is in character a prohibition. And that's why we have the Eighth Circuit, we have the Federal Circuit, we have the Supreme Court of Idaho.
So the state has to let a particular technique that may or may not have tremendous environmental harm continue while it's studying to determine exactly how severe or not severe those harms are, in your view?
It has to let it continue.
So in other words, the state can't say, you know what, we're going to put a halt to this particular activity while we study whether or not it has unreasonable environmental effects.
If you turn over all of preemption law and you put aside the interference with federal obstacles and you start revising preemption law to reflect the strength of the state's motives, I think you need a record to do that. You don't have that record in this case. I mean, we filed a lot of stuff, but it's not a record in the trial court. It's not, a lot of it they say is not properly before the court. We can demonstrate beyond a shadow of a doubt that there is nothing here that should give rise to this concern. If the court got into
okay, so now we're talking about two different questions. One is the extent of preemption law, and the other is whether or not the decision makers here made a reasoned and informed decision. You say they didn't because your studies and the opinions of other people disagree. That's a little different from preemption law. So I think it would be helpful to disaggregate those two arguments. One has to do with whether or not they're right, and I'm discerning that perhaps you think they're not. The other is the degree to which the federal government has intended to preempt this kind of state action.
Let me return to that.
And as you return to it, let me focus the inquiry in this way. The Federal Mining Act goes back to 1872. The views of governments generally and people around the country were a little less refined with regard to environmental protection then than they are now. So I'm wondering how that factors into the equation.
Well, the Act is not in splendid isolation. What about the Endangered Species Act? I mean, if this thing took Endangered Species Act, it would be subject to being shut down under the Endangered Species Act instantly. Okay? There's what about the Water Quality Act? There's 50 different acts to protect environmental values.
That may be true, but we're not examining those.
Right, but why do we need? Why? If we're worried so much about the state and the environmental values, why do we have to authorize the state to flatly prohibit any effective mining whatsoever when it's got all these other laws? I mean, to return to your point now, to answer the question, 1872, the effects that they were thinking of then were these damage to downstream lands and things like that. You can see that in 30 U.S.C. 51, which actually goes back to 1872. Then we come up to 1955, and we have there the no material interference standard. And it's quite clear that federal agencies can't prohibit or can't severely restrict to the way these people did. They can't do it. Then we have the Minerals Policy Act in 1970. Then we have the overarching Federal Land Policy Management Act in 1976, I think it was, by which time we had the Clean Water Act, the Clean Air Act, all the environmental statutes were in place. And again, the focus was on undue and unnecessary environmental impacts. This whole federal approach that gives the overriding policy of we have to have some impact to give the minerals out is what the state is frustrating. It is frustrating that through this device of prohibiting and saying you can never do it until there are no effects at all. And the effects that they're talking about are really wild. It's not about fish. The regulations say there's no harm to fish. Those were the regulations that weren't good enough. And that's where we are. We're underwater with the fish. They come in with things like, well, there might be birds, or let me take another one. Traditional cultural properties. When you're underwater in a river boiling with boulders down every winter and so forth, there's nothing there. There's no, Native American temples or anything out there. So they came up with the idea that the whole river is a traditional cultural property, and for the miners to be present in this traditional cultural property is a significant impact, and that's got to be fully mitigated. Well, how do you do that? No miners. There's no other way. I mean, and the water quality thing. The Water Board, this legislature has expanded the ban now and said, we're going to give you the power to prohibit it. And what did the Water Board say? They already are on record saying there's no way to eliminate the impacts except to prohibit the thing entirely. We can't have zero impact without prohibiting it. That's what the state wants. Zero impact. And that is what is, like giving the finger to the federal policy. It is not the respect that is due to a coordinate sovereign. So that's what I'd like to try and leave you with is there is a real powerful conflict of policy here. There is the federal sovereign that says we have got to get minerals out, and there's just going to be some effects that we can have reasonable regulation. We'll trust the agencies to deal with this, but we can't just say, I'm sorry, there have to be no effects whatsoever. And that's what California is saying, and that is an obstacle. It's clearly an obstacle. And it's because it's so clearly an obstacle that we get off on all these sideshows and these arguments about preemption law that are just completely wrong.
So can I ask you for a clarification? Is that what you are relying upon, this conflict to overcome the presumption that there is no federal preemption absent a clear and manifest expression of it?
Let me say,
I know you've talked a lot about the intent and the minerals in the land, and it has to come out and there has to be impact. And yet, I start from the place where we all start, just, the law school question of preemption is disfavored. And so in order to find federal preemption of a state law, especially implied, that you have to have a clear and manifest expression of the intent. So
we disagree. And since that's too simple, because there's case after case after case that I cite in the brief where there's no mention of preemption at all. It's a more nuanced approach, and Your Honors adopted that more nuanced approach in December.
So let me ask you, so you disagree with the statement that we examine the claim of implied preemption from the starting assumption that displacement of state regulation, quote, was not intended absent clear and manifest evidence of a contrary congressional intent?
I think there is clear and contrary evidence here, because what you
Okay,
said...
so what is the clear and contrary evidence that you say indicates
because
federal preemption
no state ever
exists?
tried to do this. No state ever tried to ban mining. Every time they tried to do it for 100 years, it was struck down as preempted. That's the background that Congress legislated against.
Did you say the banning of mining?
Yeah.
And your position is banning suction mining is the equivalent of banning mining, period?
If it frustrates the objectives. Take the Brubaker case, Supreme Court of Colorado. All they banned was core drilling. Okay? But core drilling is part of what you have to do to develop a mine. Just like suction dredging is what you have to do here. And they looked at it and said, I'm sorry, you can't do that. Or Lawrence County, or case after case. This would be a different case if they walked in here and said, wait a minute, here's 55,000 state law bans that have been in place for 100 years. Your case, last December, you said, and I quote, we have to have reason to discount the possibility that the Congress that enacted the legislation was aware of the background tapestry of state law and content to let that law remain as it was. But there was no background tapestry of state law. This is federal land, and nobody ever thought to go in there and start forbidding things on it. Until Granite Rock was decided in 1987, the general view was it's field preempted.
Counsel, could we look at the logic of your position? As I understand your responses to the Chief Justice, you do not disagree that we begin with the general proposition that preemption is disfavored.
There is a whole spectrum in which that goes. The Crosby case says, in some cases, it's so well settled you don't even mention it. In other cases, food and drug safety, where the states have been in there passing labeling laws, most of these cases are labeling laws, where there's 100 years worth of state regulation, then there's a real powerful preemption. But there's a whole spectrum of preemption here. And this thing falls into the class of cases like foreign affairs, or Granite Rock doesn't have any mention of preemption. Search for the word preemption in Granite Rock. You won't find it, because this is sort of a classically federal area. So the strength of the preemption is a function of this background tapestry of state roles. And if you're going to give respect to a coordinate sovereign, you have to take account of the degree to which these two sovereigns have been active and what their policies are and what they're trying to accomplish.
Does it matter at all that the sovereign in question, the federal government, has filed a brief disagreeing with your view of the degree of conflict posed with
I don't
federal
think
policy?
that what some attorney in the Natural Resources Division thinks about congressional intent is any more than his opinion. I mean, the whole idea that federal agencies are somehow empowered to make decisions in this context. You have agencies that, as a matter of law, in their own manuals say, we can't prohibit it. And we're supposed to believe that these agencies that can't prohibit it were granted by Congress the power to say, oh yeah, but we were granted the power by Congress to authorize the states to prohibit it. It's preposterous. It really is. I mean,
But didn't you say earlier that the federal government's take on a particular method might be relevant to the analysis? I thought that part of your argument earlier, you correct me if I'm wrong, is the federal government had taken a position with respect to this.
I was just pointing out that the only relevant take we have here, because Mr. Reinhart was on Forest Service land under Forest Service regulations, is the take we put in, which is 228.8, you do it where it's feasible to the extent you can, and then we put in the suction dredge miner who said, okay, give me a plan, and they came back with a plan and said, oh, well, you got to have your California permit. He said, wait a minute, they're not issuing permits, and so the Forest Service struck that from the plan. They were like, as far as the federal government is concerned, you can go ahead whether you have a California permit or not.
Counsel, could I suggest that if you want to reply to Justice Cuellar's question, you let him ask it first?
I'm sorry.
So I simply wanted to understand the extent to which your argument depends on positions that the federal government takes and can change.
I think those are just totally secondary evidence. The primary evidence is that for 100 years, in 1872, in the 1890 Organic Act, all the Forest Service Acts carefully preserved the minerals. 1955, 1970, 1976, we have 100 years of congressional legislation over and over again. That's what matters, not so much what some agency or what some Natural Resource Division lawyer thinks about it. And as I pointed out in the brief responding to that, he's just some kid. I know, we've done cases together. The Solicitor General, who signed the brief in Granite Rock, took exactly the opposite position with respect to exactly the same laws that were all in effect at that time. So,
well, presumably, there were some intervening events, including the decision in Granite Rock.
The law didn't change. Congressional intent didn't change at all. I mean, the law is what the law is. One lawyer says it means this, another lawyer says it means that, so what? I mean, it's what the law means that matters. And I think the Solicitor General's opinions of what the law was were a whole lot more persuasive than what, this guy's opinions were of the law. I mean, there's whole issues we haven't even covered. There's this whole process whereby states can work to induce the federal government to shut down mining, to withdraw mineral lands. Why would we have that at all if Congress thought states could just shut down mining? Why have those federal laws at all? It's fatally inconsistent with a state power to ban mining to have two different statutes, I think it's 30 U.S.C. 1281 and 43 U.S.C. 1712, something, that give these roles to states to try and get the Secretary of Interior to withdraw the land from mineral entry. Why have those? It's manifestly intent that Congress never could possibly have imagined that states would be going out and banning mining. It's just not even close. What else did he say that wasn't true? Commercial impracticability. There's been a lot of attack on the Court of Appeals opinion on this point, and in particular about the price of gold fluctuating and so forth and so on. One point that's not in the briefs is that the Garcia case that the law professors rely on was in fact overruled by an unpublished Fourth Circuit decision that I found last week, 442 FedEpox 745, which adopts a special standard in precious metal cases because of fluctuating prices. So again, there is a whole body of federal law on how to ascertain reasonability that is out there. It comes down to a rule. It comes down to a rule of reason, and I submit that it's just not respectful for courts to. It's not respect to a coordinate sovereign to just say, well, we're going to ban it. I understand that maybe somehow, some way, people think that they need to study something. The record here reflects that the studies were underway years before the ban. The record here reflects the studies were conducted, a set of regulations was produced, it was no harm to fish, no real harm to anything else, a few more. But you can't have stable mineral industries if the state is allowed to ban it and ban it and ban it and ban it. And there comes a point where it becomes unreasonable. And I'm sorry that there's not a more bright line test for unreasonability, but Lawrence County, which the Court of Appeals properly relied on, is dead on point. And it takes what's a very functional approach. It says, look at this thing and see whether it's of a prohibitory character. And that's what a moratorium inherently is, especially a moratorium that sneaks in this substantive provision that we've got to have 100% perfect mitigation, so it's not really a moratorium at all. It's a disguised ban. That's what's going on here. If you look closely at the legislative history, It's all about prohibitory intent. And it's not about just addressing the environmental standards. It's not about, I'm not here because this would be a different case if Mr. Reinhardt was told, well, you can't have a permit because here's a water quality standard and you violate it. I'd be probably dead in the water if it was a water quality standard and if he violated it. But it's because the standards approach, the effect-based approach, all of these other statutes, all of the things that are listed in the Forest Service regulations, it's because these things all were met that they had to come up with these evolving schemes over and over again to just shut these people down no matter what. And that's what this is really about. It's about shut them down no matter what, but let's articulate some environmental concerns and so forth and so on. And I guess what I'd like to say is there's a large body of law, in addition to the law that says the state's purposes aren't really that relevant. There's also law, I think the Perez case, if I remember correctly, which talks about how these assertions of motive they're just not enough. I mean, imagine if the rule were that an environmental effect could justify conflict with federal objectives. So, for example, the state of Arizona recently tried to make things hard for illegal aliens, right? So what if Arizona's position was that, well, we've got too many illegal aliens and it's bad for the environment? I mean, at some level, there's nothing more bad for the environment from a modern perspective than more people. So why can't Arizona clothe it in that and say, we can totally frustrate federal objectives because we're doing it for the environment? Or I mean, you can think of a parade of examples, but it's about interference with the federal objectives. And I think once you show interference with the federal objectives, you have made your case. We have carried our burden of proof. Presumptions are funny things. You look in an evidence textbook, you'll see there's different kinds. Some presumptions disappear instantly once evidence is produced. Some presumptions are putting a thumb on the scale. We've never been really clear about what this presumption is, but it's
so
not...
before your time runs out, since I just heard you say this all depends on this interferes with federal objectives.
Yeah.
And I have heard you say what those objectives are, but since your case seems to turn on it, would you recite for us succinctly again what the objectives are?
To secure the development of minerals on federal policy, to secure a stable mineral industry, to grant rights to mine that are being frustrated, to establish an overriding policy that notwithstanding inevitable environmental impacts, we will limit our regulation to that which is reasonable and doesn't, in a reasonable sense, doesn't totally interfere with getting the minerals out.
Okay.
That's all the statutes boil down to that proposition.
Thank you.
Am I?
You have 2 minutes.
Okay. The next thing to go to probably is I think we've covered nearly everything. Just the case, just the history of all the cases. Congress also legislates against the cases, and nobody's been able to distinguish these cases very much at all. He said Lawrence County didn't ban mining, or banned all the mining. No, it didn't. It banned new or amended surface permits. So all the existing surface mining operations could continue. So it was a partial ban, and it banned these permitted operations. And nobody said you couldn't go pan for gold. I mean, in any other context, it's difficult to imagine the state of California coming in and saying, well, you can use a teaspoon, you can use a gold pan, and that's really what the mining law was about. The mining law wasn't about teaspoons and gold pans. It was about getting out significant quantities of minerals. And our clients are here today because that's what they want to do. They want to vindicate the purposes of the federal statute. And so we have the interference with their rights, we have the interference with the objectives, we have the whole line of preemption law that's sort of like land use. What's this line between what's land use and what's an environmental regulation? Water quality standards, that's clear environmental regulation. Saying you can't use the land for this, and he admitted a minute ago, this land is dedicated to mining use. We can't really use it for that.
Mr. Bucol, your time's expired.
Thank you very much.
Thank you.
Counsel, a question before you respond to what you've heard.
Certainly.
Does your success in this case depend on this court's concluding that all mining use of the land is not banned? In other words, if we conclude, as your opposing counsel says, that everything is banned, this moratorium is equivalent to a ban, do you lose?
If it banned all mining and there was no way to
Extract the minerals.
extract the minerals in California, then I think I probably lose.
Well, I don't know
But-
about in California, but in this claim.
I don't think so.
Well, do you think there is?
Because-
Okay, go ahead.
Because, let's say the claim is in a place, let's say the claim is in Yosemite National Park or an equivalent state park or someplace
Yes,
that's
let's.
really
Okay.
special. That's probably not possible, right? This is federal land. So
Well, how about if we
in
just
some
talk about
special
this
place, why
land?
can't California say, look, we need to protect this resource, this river, these endangered species. You can't mine in this location.
All right, so that's your view. But actually, you don't take the view that this ban deprives Mr. Reinert of all his interest in the mining claim, do you?
No, no. He can mine on the land. He can mine with non-motorized methods, and he can wait till the moratorium ends.
But the economic viability is not important.
Correct. Correct. Did I answer your
You
question?
did, thank you very
Okay.
much.
A couple minor things, and then I want to talk about something. First of all, Mr. Buchel started off by saying that 30 U.S.C. 22 had to do with these local minor regulations. But that is not the meaning of the statute, because the statute says, under regulations prescribed by law and according to the local customs or rules of miners in the several mining districts. So those are two separate things. So I think we go back to what we talked about before, which is that under regulations prescribed by law includes state laws. Secondly, there's been some discussion about the United States' amicus brief, and I think the United States Department of Justice does not have briefs filed unless they go through the appropriate channels. And we were told that the Solicitor General's office approved.
And is
filing.
that in the record anywhere?
No, of course not. No. But they don't file briefs unless they're approved. And I assume this went up as far as it
And
needed
that's
to
in the
go.
record somewhere?
Hmm?
That's in the record somewhere?
Well, they filed the brief.
Well, I assume that
That's
if
in
we,
the record.
Yeah, right.
I assume if we get a brief from the United States Attorney General, we take it at face value and we don't go through hierarchies or personalities or junior attorneys or senior attorneys. It's a brief for our
Right.
purposes.
Right, exactly. Mr. Buchel likes to talk about all these cases that he says that struck down bans of mining. The cases are universally in recent history, but before Granite Rock, except for South Dakota versus Lawrence County. All the other cases he cites were before Granite Rock. And I think it's important to realize what Granite Rock ruled. So in the Ninth Circuit, the court ruled, in Granite Rock, the Ninth Circuit ruled that the county cannot prohibit the use, either temporarily or permanently, in an attempt to substitute its judgment for that of Congress. And the dissent echoed this view. Justice Powell said, The court's opinion today approves a system of twofold authority with respect to environmental matters. The result of this holding is that state regulators, whose views on environmental and mineral policy may conflict with the views of the Forest Service, have the power, with respect to federal lands, to forbid activity expressly authorized by the Forest Service. I dissent. And the majority addressed this point. And they said in their conclusion that they disagreed with that principle. So I submit that Granite Rock stands for the proposition that the state can balance these interests differently than the federal government, even on federal land. And that's what the legislature has done. And they haven't done anything unreasonable here. They have asked for a study, and they have said that we want full mitigation of all significant environmental effects. Not all effects, significant environmental effects. And as this court knows, under CEQA, significant environmental effects are judged against a threshold of significance. And the thresholds that apply here were not de minimis. As to fish, the effect had to be on a population level. As to mercury, there had to be a significant adverse effect on a beneficial use. Those thresholds of significance are in the record. We ask the court to take judicial notice of those documents. These are not de minimis effects. I understand that Mr. Buchel disagrees with that assessment. He can have a different position.
Well, he
But
can have a
he's
different
not the
position,
one who
and
gets-
he says they're not significant, and you can have a different position, and you say they are significant. Counsel, I suggest that doesn't advance the ball one iota. All we're hearing is your opinion and his opinion.
No, but
So if you could ground your argument in something more substantive, it might be helpful.
And then you may answer the question, but your time's expired.
It's not my opinion that matters. It's what the agency and the legislature decided. And the legislature decided we want full mitigation. And this agency, after doing an EIR over 2 years, costing $2 million, that is over 1,000 pages, came to these conclusions. Mr. Buchel has challenged those. Those will be litigated. But those judgments are entitled to respect. And if we go down a road of saying that reasonable environmental regulation is all that's allowed, then we start to second guess the agency's decisions. And those agencies were empowered by the legislature.
Thank you, Mr. Melman. Thank you, counsel. The matter is submitted. Calling the matter of People versus Danielle Sanchez Covarrubias. Counsel, you may proceed.
Thank you. Good afternoon. This case is about the execution of appellant for crimes that the jury never found he committed. For over 150 years, this court has held that robbery requires larcenous intent, i.e., intent to permanently deprive an owner of their property. For example, in People versus Ford, this court held that the following instruction should be given even without a request from counsel. In the crime of robbery, a necessary element is the specific intent to permanently deprive an owner of his property. Unless such intent exists, the crime is not committed. However, in the present case, the jury was never instructed on larcenous intent, and thus they were able to convict Mr. Covarrubias of various robbery-based offenses, including robbery-murder, without ever having to find that element of permanently depriving an owner of his or her property. Now, the judge did instruct that robbery requires an intent to permanently deprive the possessor of the property. But that instruction has never been specifically authorized, and its definition is in direct conflict with the definition given in Ford. And Ford has never been criticized, much less overruled. Moreover, the possessor instruction that was given is plainly wrong because it enabled the jurors to convict appellant in the absence of larcenous intent. The jury was faced with a clear factual conflict in this case as to whether appellant acted solely to help his cousin reclaim property at the premises, or whether appellant knowingly and willingly joined a plot to murder and rob an entire family.
What was the property, according to the defense's theory, that your client and his cousin were trying to reclaim?
Well, the defense did not specifically argue reclaiming property. What the evidence of that appellant was intending to reclaim property came primarily from his statement, in which he stated on 3 different occasions that his intent was to help his cousin recover some things that he left at the property.
Well, in this, as I recall the facts here, among the things that were carried out while people were being held at gunpoint were boxes of materials, a box of a VCR. There were 3 trips to the car. Is it your theory, or was it the theory below, that all of that material encompassed property to which the cousin claimed he was lawfully entitled?
No. The theory below was that property, which was carried out, all of the items that you say were stolen came from the accomplice, testimony from the accomplice, Jose Luis. And in defendant's statement, he said that everything that Jose Luis took, he took on his own. We did not intend for him to do that. He was acting as a free agent when he did that. That was the theory. And yet, because they were able to convict appellant of conspiracy to commit robbery, the appellant was held, the jury was able to hold appellant liable for Jose Luis's stealing, even though he never intended him to do that, because it was a natural and probable consequence of the conspiracy to commit robbery, which was based on an intent, non-larcenous intent. So it's not that, I should emphasize at this point, this case is not about the actus reus of robbery. The actus reus of the property is the taking of the property. This case is about the intent. A person must have, as Ford said, must have intent to permanently deprive an owner. If he doesn't, he has not formed the intent necessary for robbery. So, even though the jury was not instructed on larcenous intent, They were instructed on intent to deprive the possessor. But this instruction was, as I mentioned, was not larcenous intent. And moreover, what it did was it allowed the jury to, even though they found, if they had found that appellant did not intend to steal, he only intended to help his cousin recover his property, even if the jury found that under the erroneous instruction of based on the possessor, they had to find that appellant had larcenous intent.
Can I ask you a clarification, counsel? I know that the jury was instructed in what was then provided under CalJIC 9.40, and it talked about robbery, of course, taken from the statute. It's really described in 9.40 as a crime of one of possession. A person had possession of property value. The property was taken from that person or from his or her immediate presence against will, by force or fear, and the property was taken with the specific intent permanently to deprive that person of the property. Are you making the argument that that is an incorrect statement of the law?
Yes, what that statement does is it allows larcenous intent to be found based on an intent to deprive the possessor, not the owner. There is a huge difference between the two.
Was this case defended on the premise that Mr. Sanchez owned the gun, the VCR, the bottle of hair oil, and the guns?
Well, again, those are all axis reus.
No, I understand, but I'm trying to just clarify how this case was defended. And I understood it was not that Mr. Covarrubias claimed that these items were left by Sanchez. I think this goes back to Justice Corrigan's question. I feel like there's two arguments going on here, and yet the defense at trial was not claimed that Sanchez owned those items. Is that correct?
The defense at trial, first of all, is irrelevant because we're talking...
Well, I'd like you to answer the question.
But we're talking about and I'll get to your question, but we're talking about the trial judge's obligation to instruct on all the elements of the offense. If the trial judge has not instructed on an element, that's something that you need to consider whether there was an objection or a defense.
So you're saying that this instruction is incorrect as a matter of law, and that therefore there was no reason to object as to the CalJIC 940, because I understand there was no objection to the robbery
No, there was
instruction.
plenty of reason to object to it, but counsel didn't for whatever reason. There was plenty of...
Okay, so I just want to clarify. And
Yes.
the defense at trial was not that Mr. Covarrubias was reclaiming Mr. Sanchez's hair oil and a TV VCR and some guns and a necklace, maybe. That was not the defense. You may say it's not relevant, but I'm not asking you that question.
No, but I need to get back to that. Their defense was that Jose Luis took all of those items on his own. In the defendant's...
Mr. Ramirez. Is that correct?
Jose Luis Ramirez, yes, Mr. Ramirez, sorry. In his statement, Mr. Covarrubias said, yes, Jose Luis Ramirez was taking all these things. We did not intend that either. We went there looking for my cousin's property. The fact that Jose Luis took all of those things made him guilty of robbery, but it did not make Covarrubias guilty of robbery unless
because Covarrubias only intended to transport items that didn't belong to anybody in the house, but instead belonged to his cousin.
Exactly. And he had that intent.
Now let me ask you this. You're reading this all from the video statement that Mr. Covarrubias gave in Mexico used to exonerate Lorenzo Nunez?
Yes, it was in the record. It's part of the evidence. Certainly the jury was free to disbelieve it or to believe it.
I know that, but I'm trying to get to the specifics of the statement, which seems to be a bit contrary then to what I'm reading. You say that Mr. Covarrubias said in his statement that they went there to go pick up Mr. Sanchez's property, but the way I read it is said that they went to go help Sanchez pick up some things that were left in the house. That's a far cry from Mr. Sanchez's property that was left in the house. And furthermore, as I look at the statement, I don't know that I see anything about what they said Mr. Ramirez did.
We were just picking up some things that Antonio had left there in that house. That's certainly a basis. The jury certainly could infer from that statement that those things were Antonio's, and that it was Covarrubias' intent.
There was contrary evidence, was there not, that they drove up to the neighborhood, and then they sat in the car and came up with an idea to break into that, or to force their way into the house, steal stuff, and kill everybody inside so there would be no witnesses to their crime.
Yes, all of that comes from the accomplice, which the jury rejected.
So we have an accomplice on one hand, and we have a man who flees to Mexico and gives a videotape statement, obviously trying to exonerate one of his pals. Neither of them is necessarily the most reliable source of information.
Agreed.
But the jury was presented with conflicting facts, and there was corroboration for, as the law requires, for the accomplice's testimony.
Yes, and there was also corroboration for Covarrubias' testimony, or Covarrubias' statement. But the point is, you're talking about the jury making factual determinations, and that's the whole point here. The jury, and that's why I said at the beginning, the jury did not find that Covarrubias committed the crimes he was charged with because they never had to resolve that factual conflict, because they were only told that he had to intend to take things from the possessor. And that, if under that instruction, he was guilty regardless of whether he intended to take only get the cousin's property or if he intended to steal. Either way, he was guilty under that instruction. Let me give you a quick hypothetical that maybe will clarify things. If I left my pen on the podium here after my argument, and I go back and I forgot it, and Ms. Bellatier comes up, gives her argument, afterwards, absentmindedly takes the pen back, puts it in her briefcase. I go over to her table to get my pen. She's talking to somebody else, and I reach into the briefcase and reclaim my pen. Under the possessor instruction, I had larcenous intent. I intended to take the pen from the person in possession with it, and I intended to permanently deprive her of that pen. Under the correct Ford definition, I did not have larcenous intent because I did not intend to permanently deprive the owner of the property. That's how critical the difference is, and that's why the jury in our case never made that resolution. They never made that determination as to whether Covarrubias had larcenous intent or not. It's a very basic, fundamental requirement that all elements of the charge be found by the jury, and the jury here did not find them.
And you're suggesting that the distinction to be made is that even if the defendant fully intended to take property away from the person who has possession of it, and, and to permanently deprive that person of that property,
and give it back to his cousin,
that would essentially be a claim of right defense, would it not?
It would essentially be not larcenous intent, because there was no intent to permanently deprive the owner, because he was returning it to the owner.
So if I go in and rob a bank, do I have to? If I go in and rob a bank, do I have to know who the owner of the given
okay, I'm not talking about knowledge. I'm talking about intent. You still have to intend to deprive either the bank or whoever. You have to intend to deprive. In most cases, this doesn't come into play because intent to permanently deprive is not in play.
But the premise of your argument here relies upon a factual predicate that Mr. Covarrubias was going back to get Mr. Sanchez's property.
Yes. What it relies on is the fact that the jury could have found that. I'm not saying that you need to find that. You can't find that, and you can't not find that. You're an appellate court. The jury is the body that should have found that or not found it, and they never did because of this instruction, because of the omission of this element. Chief Justice, I also would refer to the, just going back to your question about the statement, page 3 of his statement, he says, we were just going to pick up some things Antonio had there in the house. Antonio's a cousin. I don't know what's happening because they say that the light-complected guy, they went to arrest him and he's free. Oh, wait a second. I apologize. At some place in here, he talks about not going with what the...
Mr. Lundy, I'll take a look at that videotape.
Okay. At some point, he says we did not go there to loot. He uses the term loot, and he states that I know that the light-complected guy, that's Ramirez, was looting. And he says we did not go there to do that.
Can I ask you something to address something that may not be exactly where you indicated you would focus your argument, but of interest to the court, at least to me, and that is the Witherspoon-Witt alleged error based on removal of certain jurors based on the questionnaire.
Right. Okay. Go ahead. I was just trying to think. Can you hang on for 1 second?
Sure.
I needed to respond to. Whether there was any other points I wanted to make on the other issue. Okay, well, there was just one other thing I wanted to say with respect to the other issue before we leave that. This difference between depriving the possessor and depriving the owner was so critical in this case. What it did is it changed appellant's statement from a potentially exculpatory statement that I didn't intend to steal into a full confession. Because he did say, I intended to take the property, and I intended to deprive the possessor of it. So it goes from exculpatory to directed verdict on all counts. So that's how important it was to give the correct definition of larcenous intent. Okay, let's move on to Witherspoon.
So some of these jurors were excluded based just on the questionnaire. Is that okay?
The one, number 13, certainly wasn't, because his answers were all over the place, and he was crying out for oral voir dire. And if you take a look at the Leon case that you recently published, I think it falls within the rules set forth in Leon, and it was error to go ahead and exclude that juror without allowing voir dire.
And I'm looking at my notes. You mean juror number 16, correct? Not.
I'm sorry. I apologize. Is it?
Okay.
Yes, juror. The guy who was the prison guard.
Yes, correctional
Yes.
officer. Mm-hmm.
Okay, if there aren't any further questions, I'll save my time for rebuttal.
Thank you, Mr. Lundy.
Thank you.
Thank you. May it please the court. I think this court was right in suggesting that there's sort of two arguments going on here with the claim of right issue. To the extent that the jury may have believed that appellant was going to get Sanchez's things, which I agree the statement isn't even that clear, that they belong to Sanchez, he was convicted of aiding and abetting the robbery by Ramirez. Ramirez did not defend the robbery on the basis that he believed it was Sanchez's property. He pled guilty to robbery. He stole property from the house, and even the statement where it was looking, it says the light-complected guy was looting the house. He was grabbing things and leaving with them, but we didn't go there for that purpose either. And appellant says they never found the things that they were going to get. They held the guns on the victims until the shooting happened.
Your friend on the other side would say it's a question of intent, and if you're going to convict Mr. Covarrubias of the robbery as an aider and abetter, you have to prove that he intended to aid and abet the thief in stealing that property, don't you?
Correct. And the jury was instructed with the aiding and abetting instruction, so that to the extent that Ramirez was guilty of robbery, and Ramirez testified, yes, I pled guilty to robbery, To the extent that the jury had to find that appellant intended to aid and abet Ramirez's robbery when he was in the house. He may not have gone there thinking that, and that may well be a defense to an attempted robbery of Ramon, or when they were holding a gun, but he wasn't charged with that. That might be a defense there, or that issue might be relevant if that was the defense.
So your argument is that the jury was properly instructed on the notion of aiding and abetting Ramirez in his thievery, regardless of what Mr. Covarrubias said his original intent was in going to the house in the first place.
Correct.
That there was sufficient evidence that regardless of what he intended with regard to his cousin and what he left at the house, there was sufficient evidence, and the jury was properly instructed, that he intended to aid and abet Ramirez.
Correct.
Okay. What about the Witherspoon issue?
Yes. Our argument on the Witherspoon issue, and specifically I'll focus on Juror 16 unless there's some other questions. Reading your cases in McKinnon and Riccardi, and to some extent Leon, but that involved oral voir dire, so I think that's distinguishable. But with McKinnon and Riccardi, if you look at the jurors that this court actually found were acceptable excusals, they were able to say, despite their opposition, they still said we can follow the law. And this court said that that wasn't enough when you look at the entire questionnaire to overcome their opposition to the death penalty. In Juror 16's case, he wasn't even able to get that far as to say, I will follow the instructions or I will look at the law. He said, I possibly will, and I probably will. But he was consistent throughout that he would most likely always vote for LWOP in all of those questions, no matter what the evidence. And he was consistent, very, in his strong opposition to the death penalty.
But here's the way this works. The death penalty equation is a normative one. There is a broad spectrum of opinion among Americans on its utility and morality and many other things. And the law is that the prosecution doesn't just get to get people who think the death penalty is a swell idea. You can't exclude people because they oppose the death penalty.
Correct. We would agree with that.
So it's very clear that this prison guard opposes the death penalty and that he thinks it's bad for all kinds of reasons. The question is whether, even in light of those strong feelings, he would follow the judge's instructions and return an individualized verdict based on these facts, right?
Correct.
So saying that he hates the death penalty doesn't really get you very far. We'll spot you that. So then the question is there sufficient evidence in this record that it is clear that this prospective juror would essentially never follow the court's instructions, right?
Correct. And we would argue that the answers to his questions on the actual death qualification questions, he would probably vote for LWOP no matter what the evidence. He might change his answer if the court instructed him to. He probably would follow the law. He couldn't even go so far. I mean, unlike McKinnon and Riccardi, where the jurors would say, well, yes, I'll follow the law, but that didn't overcome their indication that they would always vote for LWOP.
Okay, so when asked in the questionnaire whether he could set aside his personal feelings about the law and follow the court's instructions on the law, he writes, yes, most probably.
Most probably, which
well, he doesn't have to say yeah every time.
Well, I would suggest that does not overcome his other answers, where both in the first question where he's asked if he'll always vote for LWOP, and then when they're given those options, where he actually took the time to write in, I will most likely vote for LWOP, instead of even just checking the box. Whereas where we have jurors in McKinnon and Riccardi who say that, or say, I will look at the law and I will look at the evidence, yes, but that was not enough to overcome what this court called their vehement opposition to the death penalty. And so under this situation, we don't even have it that clear.
And can I tell you what my shorthand version of number 16's response is to, yes, under the general questions about death penalty, he was very strong. But when it came to the wit questions, he sort of softens. And my notes say he answered probably he would automatically vote against the death penalty. Then he said, and probably, as we know, is different from possibly. Then he said to the question, would you change if you were instructed to consider aggravating, mitigating factors? He says possibly he could change. But when he gets to the question that's important to us about getting to voir dire, about whether or not he could set aside his feelings, he gives us the better answer of yes, most probably. So he starts out tough, and then he starts to soften. Then he starts to think about what his role is as a juror. He's certainly given his views. We know they're strong. And then he starts thinking of his role as a juror. And then he sort of turns into possibly, probably, possibly, most probably. So in my view, that seems inconsistent. It's not, as we've said before, this does not clearly reveal an inability to serve.
I understand that argument. I would say, though, if you look then, after he makes those questions, the subsections of number 59, then you get to question 61, which gives you the option A, always vote for death, always vote for LWOP, and C, I will look at the evidence and decide, what I should do. And he then goes back to he doesn't even mark question C with just a check mark. He actually physically writes in, most likely vote for LWOP, no matter what the evidence.
Would it at least have been prudent, counsel, for the trial court to undertake additional voir dire?
It certainly couldn't have hurt to undertake voir dire in this situation, but I think when faced with the entire questionnaire and the fact that he wouldn't even commit to following the law, unlike some of the jurors that we've talked about in McKinnon and Riccardi, who actually say, yes, I will follow the law, but then they say things like, I'll always vote for LWOP. This court has found that was enough to show that it's not clear that they're willing to set aside their beliefs. And this court said in McKinnon, an ambiguous or pro forma statement that they're willing to follow the law does not bar their excusal when looked at in the entire questionnaire and their opposition to the death penalty and their likelihood of essentially telling the court, I'm going to vote for LWOP no matter what. Unless there's any other questions, I'll submit it.
Thank you, Ms. Billetier.
Justice Corrigan, I really need to get in a little deeper on this aiding and abetting business. The aiding and abetting of Jose Luis was only one theory out of many that the jury could have utilized to convict appellant of robbery. The more likely theory was that Jose Luis was a co-conspirator and that appellant was part of the conspiracy and Jose Luis was a co-conspirator and therefore his stealing was attributable to appellant. So it's not as if the jury was saying, and the thing that's significant about the conspiracy is that all happened, the conspiracy happened before Jose Luis even started doing his stuff. It even started stealing stuff. The conspiracy was even before they got to the house. There were overt acts a day or two before. So the conspiracy is formed, and the only thing that is needed to find Covarrubias guilty of conspiracy to commit robbery was the intent, and the intent to permanently deprive the owner or the possessor, and the intent was the possessor. So if he had, when he joined the conspiracy, if, as you suggested, he was intending to get his cousin's stuff,
then he didn't have the required intent.
Then he did not have the required intent for conspiracy. He should, and once they convicted him,
but they were both. The jury may be presented with conflicting theories.
Yes.
But if they were properly instructed on a viable theory supported by the evidence, then the
That's not the standard. The standard is if the record demonstrates beyond a reasonable doubt that they relied on the viable standard. And this record does not demonstrate that. In fact, it's more likely that they went on the conspiracy theory because what they did is...
Your argument falls on its own weight. Your position is the jury should have believed your client when he said, oh no, we only went there to get the stuff that belonged to somebody else. That was all we agreed to.
I'm not saying they should have. I'm saying they could have.
Well, then they wouldn't have found a conspiracy because there wouldn't be an intent to conspire to rob.
Exactly. And you cannot separate all the other convictions, including the murder, from the conspiracy either. So the point is the intent for the conspiracy was not there. Once the conspiracy is bad, everything else is bad.
So aiding and abetting just doesn't count?
What?
Aiding and abetting just doesn't count as an alternative
Well, no,
theory?
aiding and abetting was a theory, but unless the record can demonstrate that they relied on aiding and abetting and not conspiracy.
That's not the standard. For example, we know that different jurors can rely on different theories. And all we have here
certainly,
I
just refer you to my supplemental brief where I cite quite a few cases on that.
Well, I'm asking you now. All we have here is a general verdict, and the general verdict is properly supported.
Okay, let me read a little quote here.
Okay.
When one of the theories presented to a jury is legally inadequate, such as a theory which fails to come within the prescribed statutory definition, the jury cannot reasonably be expected to define the legal inadequacy. The jury may render a verdict on the basis of a legally invalid theory without realizing that as a matter of law, its factual findings are insufficient to constitute a charged crime. That's exactly what happened here with the conspiracy.
And is the case from which you cited a single theory case or a multiple theory case?
It's People versus Johnson, which was decided in 2015. And then let me go on. In such circumstances, reversal is generally required unless it is possible to determine from other portions of the verdict that the jury necessarily found defendant guilty on a proper verdict, on a proper theory. Where is that evidence in this record that they relied on aiding and abetting and not conspiracy? I think it's more likely that they relied on conspiracy because look at the note they requested. They asked, what happens if somebody joins a conspiracy after the first two people have already started it? Well, that's Ramirez. He joined after. Why would they send that note unless they were considering attributing Ramirez's thefts to Covarrubias? And in any event, it's not up to me to prove that they did rely on conspiracy. It's up to the record to demonstrate that they didn't rely on conspiracy and instead relied on some other valid theory. So it may not seem like a big thing. Oh, they said they intended to deprive the possessor. That may not sound like a big thing. It's one word, possessor or owner. But it's made all the difference in the world in this case. It converted a potentially exculpatory statement into a full confession. And Justice Corrigan, I wasn't going to play this card, but
oh, go ahead.
The CalCrim 1600 fixed that mistake. They don't say possessor, they say owner. Because they recognize that the CalJIC instruction was an aberration. All the law before CalJIC said the owner.
So now you know exactly what the committee that rewrote the instructions recognized? Is that
yes.
your argument?
My argument is that there were lots of problems with the CalJIC, and the one given in Covarrubias' case was one of the problems, and unfortunately it put him in a situation where the jury never found him guilty of the charges that they ultimately convicted him on. And that will not happen under CalCrim. In a similar case under CalCrim, it will not happen because that error has been corrected. Thank you.
Thank you, Mr. Lundy. And Ms. Billeter, as you know, this matter won't be submitted till after supplemental briefing is in. Thank you. We stand in recess until tomorrow morning.
All rise.